Good morning, Your Honors. Patrick Dervishi. I represent the appellant and the defendant below, ex-retirement life communities.
How much time would you like to save?
2 minutes, please.
Thank you.
Okay, tell me, is this an independent living facility?
Absolutely, Your Honor.
So that, and do they live in like an apartment or or Mr. Zimmer rather, did he live in an apartment or did he live like in a separate?
They live in a condominium building. Specifically, I don't know the structure, how many units, but I know that there is a multi-family unit, but it is an independent living facility.
He lives, it's just like an apartment, right? And
That is correct,
He doesn't
Your
have
Honor.
nobody's in there, professional, taking care of him.
What we do, Your Honor, in 1997, the Zimmer Sr. and his wife moved to Florida. They contracted with X to lease, so to speak, an independent living unit. That agreement is what is at the heart of the matter in regards to the creation of a legal duty. It is an independent living unit, and pursuant to that, you pay for the unit, and in addition to that, because it is a continuing care community, what X does is it provides you with the amenities, meals being one of them, transportation being one of them, in addition to having close by facilities where they provide healthcare services.
So the transportation, they agree, it's in the contract that the residents sign that ACTS will provide transportation to, do they give a limit? I mean, they're not going to
That
drive
is
them to
correct,
New
Your Honor.
York.
Pursuant to the agreement, they can pick up the phone. It's a different arm, but it's a subsidiary, so to speak, of ACTS. They call the front desk, say, I want to go to the bank. I want to go to my doctor. You get the vehicle with the driver provided by ACTS, and they take you where.
But there's a different nature of the relationship between you and your residents. I mean, you could just call Uber to get somebody to come pick you up, or a taxi company. So the nature of the relationship between you and your residents are that they're depending on you. So you have there's in the record about firing somebody for not following your rules and regulations of, I guess, not getting gifts, correct?
Correct.
Not allowing gifts. What is the purpose of that rule that you do not allow your employees not to accept gifts?
Like any other company, ACTS is a faith-based, not-for-profit corporation. It creates internal regulations and policies to conduct the relationship of its staff, the employees. Charlie Coxon, the executive director of ACTS, testified at trial that the purpose of the policy against tipping and providing gratuities to staff, we're talking about you go and eat a meal and you have a cafeteria person, you have the security guard, you have the driver. In order for these residents to have an idea that we come over here and you are going to get the best care possible, we don't allow the employees to accept gratuities. It's like going to Publix and the guy says, "Can I take your car to the car?" They don't want to make that policy so that you can get the impression that by tipping the low-level staff or that person, you are getting a better service. You are there to get what you paid for. You are in an independent living facility.
Now, what about if other employees help facilitate violating your rules? In other words, if you fired somebody for accepting in this case, correct?
Correct.
Now, the allegations were that other people helped facilitate that, correct? Weren't there other employees that alleged to have continued to drive?
Here's what the record and the testimony at trial showed, Your Honor.
Okay.
Sometime in August 2008, the son, Zimmer Jr., got wind that his father was cashing some stocks. And he got worried and said, "Dad, what are you doing?" Because he knows that he doesn't need to cash stocks or whatever it is that the father is doing. He says, "I'm using it for a friend." He doesn't know anything. The reason why he knows that there is some cash token, it is because of the father's position, employment position, because of him being a broker and being connected to the account somehow. He doesn't know anything that is going on about what his father is making gifts. And again, the testimony at trial that is admitted by both sides is that Mr. Zimmer Sr. made a total, 4 checks for a total of $30,000. This happened before X knew about any of this. In addition to that, Mr. Zimmer Sr. purchased a vehicle. He got friendly with Mrs. Roca. Maria Roca was the culinary manager. He got friendly after his wife passed away in 2004. He found a comforting soul. Everything that has been alleged, every testimony, every evidence at trial indicates that every quote-unquote impropriety, and I'm saying impropriety because that's what they alleged. We don't admit, concede, or there is no evidence.
Well, you wouldn't have fired her if there wasn't something untoward.
Because she violated internal rules which we didn't create for the purpose of eliminating the harm that they alleged occurred. And that is the question here, Judge. What is the harm?
Let me ask, did she receive the car before she was fired?
Yes, she received the checks and the car before she was terminated, before X had any knowledge of this, which is one of the points.
Was there any other monies or gifts or gratuities given after she was fired?
We don't know, Your Honor.
Nothing in the record.
Not the record showed they put into evidence checks that had been made to cash that Mr. Zimmer Sr. went to the bank, cashed out. Circumstantially, they wanted to make the case that, oh, by the way, there was money withdrawn for Zimmer Sr.'s account, and then 2 days later, Mrs. Roca went and deposited, let's say, $500. So in the eyes of the jury,
Right.
but we are not here for that, Judge.
What is your issue that you want us to consider here?
What I want the court to understand is that the issue about the violations of the internal policy have nothing to do with the legal duty. And the legal duty is what creates X responsibility in the first place. Just because I create internal policies for other...
But policies also could replicate or mirror statutes, fiduciary roles. I mean, there are a million. For example, you want to prevent elder abuse, correct?
We want to prevent elder abuse when we have the responsibility to have and the responsibility and the ability. The responsibility comes because you have an independent living unit. They have cases in their answer brief where there is a resident that drowned in a canal in a facility, in a retirement facility. But the case is specific because in that case, not only the facility is in charge of the grounds, it is also a resident who was living in an assisted living facility. Here we are.
Here's what I'm trying to reconcile, and I think it's the view from 40,000 feet, and here's the conflicting, competing interests. I think contractually there's a relationship between the plaintiff and your client.
Correct.
That gave rise to certain duties, and then we talk about negligence on the side of that. But here's what it is. There's an expectation contractually and perhaps in tort that your company is not going to allow its residents to be victimized by unscrupulous employees that want to take advantage of frail adults. That's one competing thing, and it's a fair expectation. We have Dad in here because we don't want his life savings to be fleeced by way of gifts to cars when Dad never gave cars away to people during his lifetime. That's one thing. The competing interest that I'm interested in hearing from the appellees about are that, hey, if the guy is perfectly competent and it's, he's on his last chapter, why not have fun and spend his own darn money any darn way he wants to? And so I wrestle with those two competing values at play. Is he getting taken advantage of, or is he just having fun in his last chapter?
Judge Colbeth, the jury probably saw it the same way because, remember, there were 4 claims: constructive fraud, and I'm rushing a little bit, I apologize, under influence, negligence, straight negligence, not responder superior, straight negligence, which talks to about the standard of care as to whether you have a certain conduct. That conduct is specifically included in that resident agreement. And then you have negligent supervision. The jury returned 3 of those counts in my client's favor. They found against us in negligent supervision. And by the way, I rest on the briefs in regards to the insufficient evidence in regards to the negligent supervision, because the lower court should have entered a directed verdict, because guess what? There is no harm. This case is about an able, mentally competent individual making decisions.
Wasn't there testimony suggesting the resident may have had early stages of dementia in the record?
Yes, one, it was not, there was a conflicting
But that's
evidence.
not- I mean, I understand that, but the question is, you made a statement that he was able to. It's a conflict in the record, and the jury makes decisions, not us.
Judge, the question is, was he mentally incompetent? Was he declared mentally incompetent? There was nothing. The son who had a power of attorney and never exercised it until 4 or 5 months before his father's death never knew about it. So if if the son and the family doesn't know anything about it, then how can X has? And again, this goes to the negligent claim that we got in our favor. So not only you have an inconsistent position, but you also have issues where we fall into what is the quote-unquote standard of care. Then we go, and again, in the brief, we talk about how it is difficult for the courts when we talk about legal analysis, where we merge the two, the legal duty and the foreseeability and the proximate causation. And sometimes we talk about all of those things together. You have to find a legal duty, and you go to the resident agreement, you go to the independent living facility. I have the right for the residents not to be abused, but that is not what we have here. What we have here is a gentleman who gave his money to somebody outside of the premises without our knowledge. The moment that we found about it and we were told by the family, we terminated them. We didn't terminate them because the person committed a tort or a wrong. The jury never found constructive fraud. The jury never found undue influence. The jury looked at the negligence and says, you know what? I'm going to that difficulty about I have the son on one hand and I have a stranger, and I believe that, you know what, $50,000 is what I believe that X should be responsible for. But responsible for what? If he was never mentally adjudicated incompetent, then what rights do I have? Because I can be sued under resident agreement, which, by the way, happened because, not that he was sued, the son called X and says, I want you to deactivate my father's car because I believe I have issues with his driving. George Bryan, one of the executives, went and did that, and then got contacted by law enforcement and says, you cannot do that. This guy is an independent person.
Counsel, I'm going to give you more time in rebuttal, so.
Thank you very much. I appreciate that.
And I'll give you extra time, too.
Thank you. May it please the court. Alan Rose, and with me is trial counsel Tim Wright on behalf of the appellee, the estate of Robert Zimmer.
Okay, so a guy has say Mr. Zimmer has a gambling problem, but he's sound of mind, and he asks the appropriate transportation. He calls the number that he's supposed to call to get transportation. Says, I want to go to the Hard Rock Casino. Can X legally or in any other fashion say, no, we're not taking you there?
Well, first of all, you have some presuppositions in your case, which there's some disputed evidence in the record, which is how
Answer that question.
Okay. I don't know the answer to that question because we're not talking about driving him to a third-party facility, to a racetrack, but if he wanted to go there, if he called Uber, let's say he could go there. But we're not talking about an employee of a casino or something that happens at a casino. We're talking about what happens.
Aren't you arguing
inside.
that he asked that the part of there's, I guess, two prongs or two episodes for the negligent supervision? One before Roca and the others got fired, and then You're saying it was negligent supervision with respect to the employees that drove him to see Roca after she got fired?
We think there's elements of negligent supervision in both. So if you step back for a second, negligent supervision is a tort recognized under Florida law. It has elements. The count for negligence requires that the act of the employee be within the scope of their duty. And we lost on those counts. We're not here to talk about the claims we lost on. We're here to talk about the claim that we won on, which is negligent supervision. So a claim for negligent supervision, you must have a relationship which gives rise to a legal duty to supervise. And here the relationship is obvious. It's the contractual relationship. He's a resident of this facility. It's more like a hotel than an independent condominium. He gets basically all of his services provided. He pays money in advance, and he gets to live there. And all of his services, his needs, his food, his transportation, he gets laundry, all of his basic needs are taken care of by these people at ATS. So then the question becomes, clearly there's a relationship here. We're not talking about a stranger. We're not talking about, they have no idea who this man is. He lives in their facility 24 hours a day. He's in contact with their employees 24 hours a day. His meals come from their employees. So then the question becomes, a duty to supervise occurs when, during the course of the employment, the employer becomes aware or should have become aware of problems with the employee that indicates unfitness, and the employee fails to either take further action, investigate, reassign, or discharge. That's the question. And so if you look at what they knew or should have known, we put on evidence from an expert witness in the continuing care retirement facility community for over 20 years. And she gave a litany of red flags that they missed. Antisocial behavior. Mr. Zimmer was not socializing with other people. He was spending a lot of time in Miss Roca's office, and he would show up and sit in his car and wait for her to arrive to work. When asked about it, she goes, "Well, I have a little stalker." She had building this relationship with him, and this is a man in his elder years. He's lost his wife. There's a disputed evidence in the record over how mentally sharp he was. There clearly is evidence in the record that he was starting to slip significantly, and the jury could sort that out. The jury could sort out whether he's an elderly man who should be allowed to have fun in his life, or whether he has slipped, as Selvin talks about. This is the 4th District case in 2002. These are people that come to this facility not really out of choice, but because they're in the later stages of their life. They need care. They're not able to take care of themselves as fully as they once were. They're not there necessarily. They're there voluntarily in the sense that they came there voluntarily, but they're there because this is what life has led them to. So in those situations with these red flags, this woman gave him a cell phone. And the supervisor was aware of this, that they were spending a lot of time together, that they gave the cell phone, that he was in her office, that she'd reported him as her little stalker. They were aware he was having some trouble taking care of himself. And they did nothing to look at that. It's not taking a guy to a dog track or a casino on an occasional basis. It's a guy that's there 24 hours a day, and they're observing this. They have these facts. So under the law, they have a duty to supervise once they become aware of facts, which would lead a reasonable person to know or have reason to believe.
Do you have any cases which approximate this type of situation?
Well, clearly the law sets forth what the...
I'm not talking general, I'm just talking about factual, because it's sort of a unique facts in that regard. I mean, do you have any cases that we can rely on?
Well, I think Selvin, which is a negligence case, but that's because the misconduct in there was within the course and scope of someone's employment, and this is not. But the facts of Selvin, and it's very similar in the sense of what the court did, and there Judge Gross in a footnote says the parties have spent tons of ink telling us all about standard negligence, but we view this case slightly differently in Selvin. And what he said was, we have come to see this case from a different perspective. We focus on the conduct of the defendant, which is in the business of offering assisted living facilities to men and women in their declining years, and the services and care that the defendant has undertaken to give them. And that court went on to say that it's a fact question for the jury what level of care the gentleman needed. In that case, they were saying, well, there's some people in the facility that get tremendous amount of supervision and some that get less, and this court said that's a fact question. So you've got a cause of action that's recognized by Mallory, which is from 1952, and lays forth the restatement of torts. So we've got a restatement that sets forth a cause of action for negligent supervision. there are elements, and each of the elements is satisfied here, that there is a duty to supervise, not if nothing has ever happened and there are no red flags, but once there are red flags that have come up, and not just that they have not identified, the record establishes that they were aware of the cell phone and of the constant interaction, that he's waiting for her to come to work, and they have a policy designed to prevent exploitation of these people. You're not allowed to take any money from them. Forget whether it's $1 or
The
$2.
example of the Publix, I mean, a lot of companies have that no gratuity policy. It isn't necessary to prevent exploitation. It's to probably for a number of other reasons to make sure that you're focused on the goal of helping the client or the consumer, not having external factors. Does that make it, I've used the analogy before of a hotel. I think that if somebody was in a hotel and they were giving gratuities and found out later that something untoward happened, would that make them liable?
Let's take the Publix for a second if you want to talk about Publix. So if I have a Publix, and I don't think Publix owes nearly this, see, they owe no duty to their customer when he comes in to shop. Their duty is that I don't slip and fall when I'm here. I pack your bags, I charge you the right amount, and I put it in your car.
You see,
But
let me just, no, because that's I think the key point of this case that I'm grappling with. You're saying it sort of like it's different. Why is it different? Why is somebody I don't think the Publix is the right example. I like
Okay.
your hotel better. Why is somebody in your hotel, what kind of duty do you have? You have duty for safety, to make sure that they're safe in their rooms at night, that they can get to, if there's a fire, they can get out, that type of security. But does Marriott, does Hilton have a duty to prevent you from becoming friendly or giving gifts to the bell captain, the front desk? Probably not. I couldn't think of an example. Maybe you could think of one. So if it's a hotel, what are you basing that duty, just because they're elder people? They're elder people who have the same rights as the people in the Marriott.
Well, it's not a hotel, and I was saying it's more like a hotel than it is an apartment complex, meaning that you enter and there's control, like a dorm in a college dorm. It's a facility like that. And it's not a hotel at all, because a hotel we check in and then we go about our daily lives. We eat wherever we want to eat. We do whatever we want to do. These people, they're dependent for every service. They eat every meal at Axe. They're constantly interacting with the Axe employees.
How are
On
they,
the tipping
I'm
of the,
sorry, they're dependent? They don't have to eat
they
in the
get.
cafe. They don't have to, do they?
Well, you see, and this is where we get in, I think, into they could make an argument. Look, we did everything we could do. This guy was sharp enough. We shouldn't have had any problem, or not. And that, I think, you get clearly into a jury question, because the jury could have heard all the evidence and said exactly what you may think. Well, gee, what more could they have done? This guy could have done whatever he wanted with his money. Or the jury could say, look, this looks like exploitation. We have someone giving him a cell phone. And I'm not back to the Publix, but if the Publix guy started to give an elderly resident cell phone and visiting him and spending a lot of time with him, it's a different thing. But that's completely opposite here. These people live in this facility. There's clearly a duty owed. And then the question is, did they breach the duty?
Do you have a case that says that Slavin is the only case that you're
I think if
defending?
you look at Selvin, it talks about a heightened sense of duty to them. I mean, if you want to look at Malicki and Garcia, they talk about the facts of what the elements of a negligent supervision claim is. I mean, it's a factual-based question once you establish that we have a relationship. Then the question is there a duty to supervise? And because were there facts that should have put a reasonable person on notice of a problem? And what McCain, the Florida Supreme Court in McCain says is you get into somewhat of a mixed question of law and fact when you get to that second level. First level, was there any duty at all? Is he a stranger, or is he a resident with a contract and obligations? And clearly we're over that hurdle. Then you get into this question, which is a little bit of a mixed question of law and fact, of what is the zone of risk? What's the foreseeable zone of risk? And we know the zone of risk here. We're in the bullseye of the zone of risk. It's financial exploitation. It's money going.
Let me ask this. I get the sense that Axe did the right thing when they found out that their employees were taking gifts and extravagant gifts, and so they fired her. What evidence is there that Axe was aware that the relationship continued off the radar screen off campus when when the other employees were doing their job of transporting the guy around, but taking him back to the same woman. I get the sense you're saying a duty arose for at least Axe to call the son and say, hey, your dad is still being taken over to this woman's house. You may want to look into it and let us know what you want to do about it. What evidence is there that they were aware of that continued questionable, unsavory relationship?
It's actually the opposite of that, because the son, and they promised the son they would never let him have contact with the woman again, and they continued to do so. But this was a jury question, and you got to take the facts in light most favorable to us. And our position is, before they fired her, they should have known of this long before they fired her, based on the red flags that our expert testified that the jury could reject. Even worse, though, after they terminated her, their drivers, even though they promised not to put him in contact with this woman that already had exploited him, they continued to drive him there, and they allowed him to walk through the facility past the guards and get into a car, be driven by Mr. Roca and sometimes his wife.
The management knew, is there record evidence that the management knew that he was continuing to visit with Roca?
There's disputed record evidence of that. It's a jury question of that. And the checks afterwards, there was some question about the checks. This is a gentleman who was starting to take out large sums in cash, and we proved that it coincided with deposits she made of large sums of money for someone who was now unemployed. Where she deposited, he took out $3,000, she deposited $1,300. He took out $3,000, she deposited $2,000. So we put on evidence a whole laundry list of several $100,000 of checks that were deposited after the fact. It's still our position that they owed a duty to supervise, and they breached it according to our expert and undisputed evidence long before they fired her. And then after they fired her, they still had a duty to supervise, and it got worse. On the damages, there's clearly enough evidence in the record of several $100,000 worth of checks, in addition to the Mercedes that there's no dispute about, and the $30,000 in checks that were to her. But
Counsel, could you wrap up?
Sure.
Let me ask a question. Was there an underlying tort here?
absolutely.
Which was?
Well, don't forget, we settled with Roca, so we let her out of the case. So if she clearly committed a fraud or an undue influence, which are both recognized torts. So there's clearly a recognized tort that she committed. She was their employee, and she did that outside the scope of her employment. We've settled with her. So then the question is, do they have a duty to supervise? And it arises not in the abstract and not in every case, and not for the entire world.
Did the drivers that took him to see her, was there a tort on their part?
No, she was committing the tort, and they were not being properly supervised.
Fired. Yeah,
they were not being properly supervised.
She's no longer, they have no authority over her after she was fired. Correct?
Well, they don't have authority over her, but they have authority over the employees that worked. In order to find
those employees committing a tort.
Those employees were not committing a tort. That's not the issue. They were not being properly supervised.
How can they be hit for negligent supervision if there's no underlying tort?
Well, there isn't. She was still committing fraud against them, and
She doesn't work for them.
They were allowing the fraud to occur by not supervising. But here's the thing I would leave you with. In order to find for acts, you'd have to find that this facility owes absolutely no duty whatsoever to this gentleman, no matter his mental health, no matter how much it's declining. They have no duty to protect him from their employees taking excess amounts of money even after they're aware of it. I don't think you can make that finding as a matter of law. You're not setting a precedent that's going to send us down some slippery slope, because this is a fact by fact case, and the jury sorted out all these facts and could have agreed with everything that you may feel, which is this is a big much to do about nothing, he's an old man, or they could view it, look, this is wrong based on these facts, and they get to judge the credibility. Just briefly on the proposal for settlement, just for 30 seconds, because it's a significant issue. We followed the statute and the rule exactly and said this is attempting to resolve all claims, and the only damages that were sought in the complaint were money damages. All 4 counts sought only money damages, so the proposal is perfectly enforceable and should be upheld as well. Thank you, and I appreciate the extra time.
Counsel, I'll give you 3 minutes.
Very briefly and very quickly, and I apologize for that because I'm going to rush again. Judge, he could have gone to a casino, he could have lost all the money, and X would have had no duty whatsoever to do about it. That is exactly, and I'll take it from the back, that is exactly what happened. Even if X knew that the people working, the employees were transporting him to her, there is no tort, because he could have done anything relating to his assets. that driver becomes exactly like an Uber driver. And X has no authority over him because there is no underlying tort, there is no fraud. If they settled with her, they settled with her. Has nothing to do with X because all the X have been outside
You're
the.
saying that somebody can aid and abet the commission of a tort, or in this case, aid and abet theoretically a crime, and which could also be a tort, and as long as they don't commit it, you are not liable for aiding and abetting this commission.
And I'm not saying that at all, Judge, and I apologize if may have led you to believe that. What is the tort? What is the fraud? What is the commission of the crime in this case? There isn't none. The DCF found no wrongdoing. The state attorneys
Well,
rejected.
They look at it from a criminal justice standard. They don't look at it from a civil standard. Just because DCF says there's no violation of Florida statutes for elder abuse doesn't mean per se that there isn't a civil tort.
And I think the jury talked about that when they rejected the negligence case. And the whole thing about the red flags, Judge, it's not true. That is when we come, again, you have to look at the dispute from the legal duty, which in that case, you're not going to the hotel example. The hotel would have a higher duty to supervise its invitees. Because in this case, we have an independent person. By the time that he was driving himself, he didn't have to use X transportation because until November of 2008, and Mr. Zimmer died in July of 2009, Mr. Zimmer was driving his vehicle. It is conceded and acknowledged that all the checks that were given to him outside of the scope of the employment. So again, even if there is an underlying tort, which there isn't, this case was never brought up by the pleading as a respondent superior. It was just a negligence. And in that case, those facts, those red flags, allegedly, they become important only when you talk about the standard of care. They don't become important because there is a legal duty. The legal duty is the legal question. And they can go back and forth and say, well, this is a jury case. And the jury just looked at the facts. We cannot hide behind the jury. The judge had an obligation. The law requires him to say, I'm going to give an instruction, duty or no duty, before he sends the jury to the charging conference. Again, what we have over here is we don't have a harm. Very briefly on the negligent supervision, counsel stated the elements. Let's look at the elements. You have to be on knowledge of the harmful propensities of the employee, which were what? So far, there hasn't been any record. The evidence showed that X conducted his background check. They passed. This has never.
Could you wrap up, please?
Thank you very much, and I hope that the court looks at the duty, looks at the lack of the duty in this situation. Again, it is case specific. The directive verdict should have been granted, and this case should have been given in favor of X. Thank you very much, and thank you for the extra time.
Thank you so very much for your arguments.
Okay. Last case for the morning.